Understanding our rights if we ever need workmen's compensation can be a bit confusing. And to help us comprehend, we have attorneys Marc Anidjar and Shire Patel from the law offices of Anidjar and Levine, accident attorneys. Welcome back, guys.
Always great to be here.
Yeah, and I'm going to throw it right in there because we've heard about this story going on. South Florida, this worker, right, essentially at the dealership, something went wrong with the elevator. Tell me about how, and I know you guys are handling this case.
Yeah, so this case actually is one that we actually represent. It was a dealership where they had this elevator that was designed for the cars to go on the elevator and bring it down a level on a platform. So it was an elevator designed to hold a vehicle.
Okay.
In this situation, the hydraulic system failed. Obviously, the car collapses while one of the employees was still in the car and he got injured. So in this instance, there's more than one potential claim, right?
Okay.
You obviously can have a workman's comp claim. Workman's comp is fairly simple. It's, are you on the clock? Did you get injured on the job? You don't have to prove negligence. You don't have to prove anything. It's just by virtue of you being on the clock and getting hurt while you're working. In this other instance, I think with the case that we're pursuing is against the elevator manufacturer. Happens to be that 8 days prior to this incident, they had had an elevator inspection. And that inspection cleared the elevator for use. And here we go 8 days later, and we have a failure that results in this collapse. So as a business owner, you know, obviously this is why it's important to do all your safety inspections, keep your elevator certificates up to code, because by virtue of doing those things, now you've offset that legal responsibility from you to the company that's supposed to be maintaining those items. Right?
Wow. Okay. So, and you mentioned something, Marc, and I want to ask Shire as well. So you have to be on the clock, but what happens if perhaps you just clocked out for a few minutes and then you do get involved at the job in an accident? I know it's a little, you know,
so
gray
if you're
area.
on your lunch break and you decide to stay in the property and eat there, that would be a question for Phil Feldman, who's our work comp attorney. You know, my expertise is in personal injury. There is area nuances. Sometimes with state employees, they do cover them to and from work. Other policies are having specific exclusions on those issues. So it really goes down to the policy language on what they're going to coverage. Sometimes with obviously state employees such as police officers, because they're using their work vehicle to go to and from work, they expand the territorial coverage that they're going to afford that protection for.
Okay, and for filing the claim, do you go immediately to HR or can the employee go ahead and contact somebody else?
That's a great question. You can do it either way. You should definitely notify HR or your manager, and they could start that claim for you. If you get an attorney involved, the attorney, we would handle it for you by notifying the comp carrier and opening up that claim so you could focus on the medical treatment. There's still a big component of getting better, which is important. Either way.
Two separate issues. One is obviously as the employee, you have an obligation to notify the HR manager that you were hurt on the job, so there's a formal record. And obviously on the attorney side, we would put the insurance carrier on notice and notify them that we're intending to make a claim. So two separate notifications that need to take place.
Very important, and of course, you know, considering hiring an attorney because the entire process, it could be a little long, and of course we want to share your information right now on your screen. If you are right now needing to get any guidance on workmen's compensation, you may call the law offices of Anidjar and Levine, accident attorneys.